Hello, good afternoon. Welcome to Single Parent Action Network. Today we have special invited guests, including Ms. Rachel Edmond, Mr. Kevon, Ms. Tremaine Jules, and Ms. Michelle Mitchell. Ms. Michelle Mitchell is our communication specialist, and she's the expert at enhancing our NGO at the moment. Ms. Edmond is the founder of her NGO, and she'll give us a little insight about her NGO, and we'll go forward. Our topic today is rights and responsibilities. And we'll expand to speak about the family court, and we'll see how interesting this topic will lead us. So where would it go? Thank you, Ms. Edmond.
Good afternoon, everyone. Good afternoon, Trinidad and Tobago. Thank you, Arita, for having me once again. The Global Network for the Advancement of Single Mothers, as the name suggests, is an NGO that has been formed back in 2015 to assess and address the needs of single mothers across Trinidad and Tobago. We've been working since 2015, incorporated in 2018, and we've had quite a challenge over the last couple of years due to the COVID restrictions and all of that. We usually work in conjunction with other NGOs to provide services to single mothers, and we are currently looking at introducing some various projects. I don't want to go into that too much. Various projects to create employment for single mothers, as well as to generate income for the organization, because we are not currently funded by any state entity or any other international organization. So that those things usually take a while. So we have to find ways to generate income, and that is one of the projects that we will be using to do so in the very near future. We are just waiting actually on our partners to approve our project. So that is basically who we are, why we are here, and what we are looking to achieve within the next couple of years and so. And yeah, that's us in a nutshell.
Thank you for being here with us. So we all come here for one special purpose, our children. And our children all have been somehow passed through the judicial system. And as parents, we all have observed that there's some little minute areas within the judicial system, also known as the family court, that is affecting our children. Ms. Mitchell, do you want to lead us off in our discussion this afternoon?
Okay, so we basically this evening want to have a discussion on rights and responsibilities. Very often we hear, especially in access and custody matters, that the party who does not have custody care or control will make the statement, I am paying my maintenance, but I cannot see my child. As though because they happen to be linked together as connecting matters in the court, one thing is a precursor to the next. So once I pay, I have a right to see my child. What many people don't understand is the child is the one who has rights of access. But with the rights of access, parents are supposed to be responsible parents who parent intentionally, and person whose environments, characters, actions, and operations do not expose those children to clear and present or lingering danger. So today we want to talk about rights, roles, responsibilities. Very often in court matters, we see that rights are misassigned. For example, I'll give you my own experience. So you have a partner, you're no longer together, you may have had access, but then you come to a place where you discover that that partner has been abusing the child in some form or some fashion. But the court continues to insist that despite the fact that the child is being abused or has been abused, that the abusive parent has a right of access to the child. So we want to talk about cases such as those. We want to talk about instances such as those, where there is a misassignment of rights. but where those rights are being accorded and afforded without the counterbalance of responsibility. Because if rights are not tempered by responsibility, we will have an abuse. And that is what we've been experiencing in the system. Miss Edmond, I see you shaking your head. I think this
I
might be a
think
good one
even
to invite you in.
yes, I think even it goes the opposite way in that sometimes, because for example, in my case, um, my child was actually taken away from me because of the fact that it was alleged that someone was abusing my child, and that someone was the person that I was living with at the time for a number of years. And so I had to go through that. So it doesn't only mean that the parent who is accused of something, let's say the father, they were accused of touching or whatever sort of abuse, it also works the other way. As long as the child presents some evidence or makes a statement that I am being abused in some way, the persons who are charged with the responsibility of caring for that child, whether it be a teacher, whether it be a pastor, whether it be a police officer, whoever it is, once they receive that report, they are responsible. Because remember, the law also says that if you um, are in, you have that report in hand, some child has disclosed, you
Yes.
are to act, and failure to act is a charge, right? So you have to also consider what happens on the other end. Sometimes things are not necessarily the way that they appear. Sometimes they are exactly the way that the child has disclosed, right? And we have to, it's a very stressful process, very, very stressful, especially when it comes to sexual assault. It is very, very stressful. And I don't think that we talk enough about what happens in those cases, where you have to go through that actual process. Most times we are going through the process of, I don't have access, I'm paying my monies and that sort of thing. And that's where it stops. But we hardly ever hear of instances where parents have gone through the ringer of um, the court system, going through that entire process where abuse and neglect and stuff are concerned.
Yeah, you made an excellent point. Once someone has knowledge or there's a reasonable belief that a child is being abused, that person is legally bound and compelled to make a report or to bring it to the attention of the authorities. Now, notice, Miss Edmond, I didn't gender specify because in the whole thing, I was accused of being the abuser.
Yeah,
But then we found out that there was abuse happening on the other side. So that's why I didn't specify to any particular gender. And I'm happy that you made the point that it is
yeah.
not specified to any particular gender. And you made an excellent point as well. We stopped the topic short. And today we are going to do the topic justice by expanding it.
Yeah,
So if
Okay.
yeah,
Mr. Yvonne or
because
Tremaine would like to jump in at this point, right after you, Miss Edmond, go ahead.
yeah, because we often think, well, we live in a society where we have a lot of male on female violence, right? So
Mm-hmm.
automatically, a child discloses somebody is abusing me, we think a man, right? It doesn't necessarily have to be a man. It could be the mother who is the primary caregiver. It could be a mother's relative. It could be a
That's right.
father's relative. It could be
Right.
some teacher in school or somewhere they are, karate class or something of the sort. So we have to be very, very careful when we are discussing these issues, and even when we are we may be placed in that situation where a child discloses to us, right? Or we have information of some child somewhere, that we are related to in some way. We have to be very careful to not make the assumption. We have to get the information to know how to deal with the problem. Because when we do that, we fall into stereotypical roles, having making assumptions as to the gender of the person who is the perpetrator, the alleged perpetrator.
So true. So no assumptions. You must operate only with information. And that information has to come through to us through investigation. We have to substantiate those claims. But Ms. Edmond, I am sure that you can testify that sometimes someone just makes a claim.
Yeah.
So if
Sometimes there is actually no basis or foundation, and someone with malaforethought, someone can maliciously make a claim
Yeah.
against you, against Mr. Kevon, Arita, against Tremaine, against myself, just to cause upheaval. And where does it put us? Where does it place us then? What
Well,
happens
Well,
now? Go ahead, Arita. Sorry.
in my case, I am looking at the right of a child.
Mm-hmm.
And we are hearing whether if a child is being abused, there are steps and so forth to be taken. And I'm sure in my case and hundreds of other cases, children would have been forcibly removed from our custodial care
Mm-hmm.
without proper investigation, without a thorough investigation, and decisions were made to harm our children. And we are hearing the advent of the Justice Jones report. And I'm always asking the question, how did these children leave one environment to enter another? And the state, to me, somewhat led to further abuse of these children. And continuing going forward, I am concerned as to how the state agencies intend to alleviate this problem. Because, in my opinion, they are misguided or probably don't understand the term abuse. So somebody makes false claim, false allegations, court neither investigates nor officers investigate and start to treat the alleged perpetrator wrongfully. That is my 2 cents about how the approach of abuse is being taken, investigated, and dealt with.
That's right. True. Now,
well,
before,
If I
just
may,
hold on just a second. When Ms. Clark said decisions are made to harm our children, what she meant there, decisions are made which harm our children, because judicial officers don't do it with the intention of harming our children, but they end up doing so. So let's just put that little disclaimer out there one time.
yeah.
Thank you.
if I may continue, Kevin, yeah. Um, Understanding the concept so far from the three individuals before, there is a kind of a mix-up and there is no surety. That is the problem with treating with issues. There is no sure way of doing things because I could see on the flip side that you are saying you are the Miss Edmond, you were treated in a particular way. I could see on the flip side that there is a switch that is turned on and off, that you were treated to the way some other people supposed to be treated, while somebody else may be sheltered based on their affiliation, who they know, and what they do. So if we have a steady way of treating with something, especially children, in these matters, it will alleviate the flip side of the abuser, the abuse, who is the abuser, and the gender of that. Because what happens in most cases, once you have friends and family and affiliation in this small island, you may not feel any of the justice system's recall or remorse or any harm onto you. You actually may be sheltered. So, in treating with this issue, we talk about the responsibility, not just from parents. Because if something happens, let us say in the other party's care, and the other party is not aware of such, and it is not the other party that did it, it is also the responsibility of the other party to find out
That's
and
right.
be given that opportunity to work together to find out what happened rather than be treated like a
Yeah.
Yes,
abuse,
definitely.
yeah, or the abuser.
Like a
We
criminal.
talk about the roles, like a criminal, so being a criminal. We talk about the roles. We know that the roles of in family life is very critical, right? And right now, all the pressure is being placed on the institutes because the institutes now have taken up the roles and responsibility of family members as well. So we not really fostering through institutes family life because institutes operate by policies and they operate by written agreements and written protocols. In family life, they have ups and downs, they have ways and means of getting around things. That is where I thought the family court, even the name family court, would have subscribed to a place where it is not, for example, Tom versus Dick. It is not X versus Y. It is a matter brought before the family court to actually treat as an issue and find solutions to the problem. So it's a place of solutions to problems, not a versus. And I think that is where one of the issues is when they hear family court, automatically, although there's rules and guidance and laws that abide such, it is not a place that is operating as such a solution to problems. So when I go to the court and I have an ex party there, I will believe that, oh, it's I versus you. And most of the times it's not I versus you, is that we have invited a third party to mediate on a solution that we cannot do it for ourselves. So the operation of the family court is supposed to be more intimate, understanding, as well as taking time into consideration and a lot of factors. So I think the role, the responsibility, and the right all mix up together. And as a result of that, parents seems to not know, or adults seems to not know actually what is really the role and function of the family court.
Sometimes it seems even judicial officers do not understand their role. And I'm sure we've all experienced it in dealing with the family court and the children's court, where judicial officers do not seem to understand their role. Because as Kevin is saying, when we as parents who supposedly have the welfare and well-being of our children at the heart of our actions cannot see eye to eye, then we get an independent, impartial, but invested third party who would sit down and mediate to help us come to some sort of workable solution in the best interest of the child and toward the end of maintaining all relationships. Even if you and the mother, you and the father can't be together, you want the child to have a relationship with siblings and with either parent. But it must happen when those parents are operating in the interests of the child, because some children should not be exposed to their parents, and there is no getting around it. Some parents are toxic and they are harmful to their children. And
Mm-hmm.
when it comes to that, the rights of the child has to supersede the right of the parent, because a child has a right to a parent who is not harming that child, who is not abusing the child, who is not damaging the child in any way. So not because you are named mother or father biologically means that you have right of access to the child automatically or even legally. And sometimes judicial officers do not understand that. You know what, Miss Edmond, and you made a great point. What happens to the rights of the accused? And Kevin, you brought it up as well. You have a right, even though you have been accused, you have a right of the presumption of innocence until your guilt has been proven. But I am certain that every one of us here can testify that once an allegation has been made against us, we have been criminalized by the system, the social
Yep.
support system, and by the very family court that is supposed to help us to advocate in the best interest of our children.
I
What
just
about
want
that?
to I just want to um, insert one thing here, and that is not all matters go through the family court. The magistracy still exists, and
Yes.
in my case went through the magistrate's court because that is where it was filed, right? So there's even that difference in how matters are addressed in the magistrate's court as opposed to the family court, right? Um, something else I wanted to add was that in my case, right, as soon as the the um, the protocol, which was that you go to the hospital, you go to the police station to make a report. The teacher would have gotten the report, so they inform the police. Then the police say, okay, well, we have to go to the doctor. We have to see what's going on here. After that, um, she was removed immediately, right? So in the split second of I sent her to school in the morning, and by the evening time, she was not in my home, right? Because by lunchtime, I got a call, and they didn't tell me what it was about. They just said, get down to the station here right away, immediately. I had to leave my job, and I was in the middle of, I was working at the bank at the time. So I imagine that, right? And you leave your job, you go to the station, the medical report comes back that there was no evidence of anything like that, sexual, that is. Um, so I am thinking, well, okay, no evidence means nothing going on here, but no, we are not educated as to how these things play out. No, as long as there is a report, then an investigation ensues. So even though the doctor's report said there was no evidence of sexual assault, right? They still had to do an investigation into what was happening, what statements were made. And the protocol is we remove the child from, and in my case, I'm referring to my case, I know of many other cases, but in my case, my daughter was with me for up to 10 years at that point in time, right? And her father was not active in her life. And he was not paying maintenance and all of those different things. And we had an order in the court saying that he had to pay and whatever, but you know, going through the court system really drains your finances, really drains you emotionally. So I didn't have that time to keep back and forth to say I want $400, enforce the $400. I didn't have that time. So I was going along on my own. And then now, so you have this child who has known one home for the majority of her life, right? Yes, she may have gone to her father's place and so forth, but she never lived there, right? And at the time, I also had a 2-year-old. So you have that unit. She's accustomed to that. Her right to that sense of stability was removed, was taken away, was infringed upon because you just saying, okay, this is the protocol, right? If it is you in that case, for example, I think the protocol should try to ensure that the child's stability remains intact,
That's right.
right? The
Yes,
allegation was not against me.
that's
The
right.
allegation was against the person I was living with. And
That's right.
therefore, it should have removed him
Him.
from the situation. If you're saying, okay, we're going to be doing an investigation, yada yada yada, I understand
Mhm.
that you have to ensure that the child is safe. But the child up to that point, you had no reports of any kind of anything. Whether I never even had a parking ticket or anything of the sort. Never been in trouble with the law. So
That's
you're looking at everything in terms of what is going on with this particular family unit. And if
yes.
the allegation, the report that was made was not made against the primary caregiver, then it means you need to address who it is and remove that person. You try as much as to keep the child's family unit where they
In
are
time.
intact,
Yes. Yes.
right?
Any
But you
sort of
remove the
upheaval.
child
Yes.
to somebody that wasn't caring about her, doesn't know very much about her, and you put
Mhm.
her there, right? And I know of many other cases where these things have happened,
That is the
right?
protocol. Always. They just snatch the
Yeah,
child out of the home. But you know,
yeah. And
the
then you put
interesting
them,
thing, Miss
if there's no
Edmond,
family member, you make the child a ward of the state and
ward
all
of
these
the
kind of
state.
different things. And you are inflicting so much trauma on that child.
But
Miss
there was
Mitchell,
say that you knew what was happening. As you
Yeah.
said, the report was not made against you, and there was no indication, there was no utterance or allegation that said it was happening with your knowledge. Why then remove the child from your care? Why not remove the individual against whom the report was made from the situation and keep everything else that maintains the child's well-being and equilibrium intact?
But
Because
Miss,
the truth in the matter that the manner that they did worsens the matter. Yes, Miss Clark.
but in my case, there were no allegations of child abuse. There were no physical, verbal, no allegation, no evidence. And my child was dragged out of my hands at gunpoint, taken to a home for abandoned children, and forced into an institution, into, as Ms. Edmond just stated, a new environment where the child doesn't have any acquaintances with anyone. And that immediately after that 14-day period has disrupted my child from 2015 to now.
That's right.
Mm-hmm.
And it's the same thing we're saying. Judicial officers do not understand their role or their responsibility. The social services unit do not understand their role and their responsibility. Because as Ms. Edmond said, children thrive in an environment where there is consistency, where there is pattern and routine. And for you to just snatch a child out and place her somewhere, it does far more harm than good, especially when there was no reasonable or sound basis on which to remove her daughter from Miss Edmond's primary care. And why is this being allowed to happen? Because a precedent has been set and no one has, up to this point, addressed it.
Mm-hmm. And listen,
No,
these matters take years to resolve. They don't resolve themselves in 6 months. My daughter was out of my care after being 0 to 10. She returned at 13 years old. And I could not and I could not have any contact with her. So
Why?
how is that really in the best interest of the child?
no, may I?
Sure, Kevin.
No, I'm hearing one. You see what? I've went through something different, totally at the flip side. What you have went through and stated is that the protocol. I have went through something to the opposite, and a protocol in dealing with a child cannot continue to be a protocol because it could be broken. There must be a law enshrined that guides the operation of an investigation of an abuse. International best practice is that you have 72 hours to investigate, to examine a child of a sexual nature to gather evidence. After that period, you have to depend on what the child could say, not medically. And currently, there is no law that allows that. And if a law is enshrined to that, it will force a number of persons into action. And that action will allow either the perpetrator to be caught earlier or the person who accused to be freed from that much earlier. And I think that is the issue. A law to be enshrined that guides the appropriate formality of abuse and medical examination with experts in this matter that could represent that medical examination of either proving someone innocent or proving someone guilty.
Establishing someone's guilt,
And
either
that is
establishing
the
innocence.
precedent. I've
Yeah.
heard it, the Attorney General talk about it a couple of years ago, that he mentioned it in Parliament, allowing 24 hours, and I've seen it slip under the rug. That today a lot of people are being institutionally abused because of that, institutionally neglect because of that, and a lot of things are left with a question mark. And that cannot be the continuation of how we treat children, and much less trying to get abusers to be caught and persons alleged to be abused to be freed a little earlier.
Yeah.
Yeah.
Excellent points. There are no standard operating procedures. Even if you don't have a law, you have these beautiful units with these wonderful sounding names. Do they not have standard operating procedures? Come now. Miss Claire Guy Allen is always speaking. What you do with DV matters, what you do with children's matters, which would seem to suggest that there are standard operating procedures. However, Kevon, you made a very good point earlier on. Sometimes there is undue influence because of connections.
Yeah.
And in our little island, unfortunately, we cannot get away from corruption in the system. Because, Miss Clark, on what basis was your child not yet 3 years old ripped from your hands? You hadn't abandoned her. She had
No.
been with you. So, what was the basis for it?
Well, as we are saying now, undue influence, because if it is the other side made an application it was an emergency application, claiming they were denied access. In my confused mind at the time, how could a denial of access turn into an emergency application, turn into a child becoming a ward of the state, and no investigation done? And what was confusing to me, the learned judge, during that period of 14 days the child was at that institution, she never ordered for an investigation to be done pending whatever. And the question I keep on asking her, although she told me I was very disrespectful, on what grounds did you make my child a ward of the court? And I remember Children Authority legal officer telling her, alongside legal aid, legal officers telling the learned judge, ma'am, there you have no grounds in making this child a ward of the court. Because the confusion was, there was an application before you for custody, and then you, the judge, making an ex parte order without the knowledge of the other party involved. So everybody were confused as to how the decision got to that. Did that judge ever think about the repercussions it would have on the child, or was that judge seeking the interest of the other party?
Clearly, the judge was not seeking the interest of the child, which is what the judge is there for, to seek the interest of the child. And that is the point we're making. Judges at all times, all judicial officers at all times must be impartial. But when we are seeing clear instances of bias, what are our rights? When we are stripped of our rights, who is to be held responsible? Where does the accountability come in?
And
May I cut in at this point?
Go ahead, Kevin.
May I? And bringing up that issue is I think it is in the public space. The people who are the upholders of really the law are the attorneys that guide, stand up for us. And that is not what we are seeing. That is not, I am very passionate about it, because that is not what we are seeing in our country today. Because we as parents, or we as citizens, not supposed to study law to be able to represent our voices. We're not supposed to be able to do that. There are persons that are enshrined and took oath to do that. And I'm thinking at this present time that all our issues and problems can be solved when this legal profession that is so held in high esteem in the world really take their true meaning and true understanding of what they signed up for and stand up for all this that we are speaking about tonight. And they're not doing it. Reason being is because judicial officers are taking their same immunity that was given to them to be impartial and do their job, and creating fear amongst the legal professions by the people who are assigned to stand up for our rights. Because you hear attorneys speak about issues representing the court that you will have, and you'll say, why is this taking so long? And that attorney will not dare stand up before the court and represent the true information given to that court, because they are fearful that you just one client that they have, one client. They have thousands of clients they may have to face that same person. And that cannot be the same immunity given to judges that they use, or judicial officer that they use, to put fear into the people that's supposed to represent our voice. And I think that is a serious issue.
And the other thing I have on it, Mr. Kevon, we are saying that they are legal officers, but from my experience, I have observed that the legal officers, inclusive of the judges, magistrates, and lawyers, tend to want to differ from their profession and become social workers and psychologists.
That's
And
right.
sometimes they are telling you, the client, well, this and that. And I'm like, but leave it up to the judge or the magistrate or the master. So why did you study law and you want to counsel your client, you want to mediate your client, you want to get involved in everything else except applying the law?
That's right. Back to
And
roles
one
and
thing I want to
responsibilities.
share as well, one thing I want to share as well is that these judicial officers, from attorneys to magistrates and judges, they do not treat you as a human being when you enter their court.
They do not.
They do not. I remember I was sitting waiting outside for my matter to call, and this elderly gentleman, whatever his matter was with his family, he went into the court, and I was sitting outside and hearing everything and the manner in which the judge was speaking to him like if he was some little child. And this man I am talking about could be my grandfather. He had white hair, right? And you speaking to people, you operating as if people have no brain, they can't think for themselves, and worse yet, if they want to address the court without an attorney, you want to represent yourself and say something, and you don't have the opportunity to do so.
Miss Edmond, you hit the nail on the head. I distinctly remember the learned judge telling me, Miss Clark, if you don't comply with the order by Friday, you'll be incarcerated. I asked for what? The other party did not show up for the minor child. While we went back to the court matter, within a couple of days, the learned judge intimidatedly called the police officers, take she down. And I'm like, why are you doing that to me? You had a right, if the father didn't come for the child, it was your responsibility to find him to give him the child. So I'm going to send you down. And I said, what are you going to send me where? Prison? And she said, yes. And I'm saying, but in my mind, as we all are saying, was there a precedent if somebody does not comply with an access order? And further, I call this lady the queen of all judges of all orders, because the amount of orders being made at one time, I was confused as to which order should I comply with or not. But you, the learned judge, intimidating me while a matter is going on, terrorizing me mentally, because remember, I'm leaving Tobago to come to Trinidad. And there it is, you are telling me, Miss Clark, you had a responsibility to give the father the child, even though he didn't show up, so I'm going to incarcerate you. Is that the law? Was that practicable?
Exactly.
That is against the law. And let me tell you something. Kevin made some very good points. Number one, we need to understand your child important to you, Miss Edmond's child important to her, all of us. But when we go to an attorney, ours is just one of many other matters. So it's not as important to them. The people we're looking to stand up for us, it's not as important to them. It's one of many matters. Number two, the legal fraternity is a small and close-knit fraternity. So when they say my friend on the other side, it's probably someone they went to UWI with or went to Hugh Wooding with, because they will mince up each other in the court and then they will knock glasses at Christmas party in the same judge's house. Let me tell you something as well. You see that matter of fear? I am representing myself. And you know why? Because my attorney flat out said to me, when I pointed out to her instances in which, according to law, there had been mismanagement of my matter, she said she cannot afford to upset that woman, because that woman has a reputation for making attorneys' clients suffer.
Yep.
So she has a reputation like that among attorneys, and nothing is being done about it. But your child and your matter could be secretly sacrificed, and you are not getting the representation that you are paying for. And that is unethical. It may not be illegal, but it's unethical.
I agree with that, because I remember in one instance, I told the learned judge, ma'am, whenever the child has to enter the police station, she holds on tightly to me because she's afraid. And that learned judge said, Miss Clark, you have psychiatric. I said, what? Psychological. I said, what? Problems. So I'm sending you, she used 2 words, so she wasn't sure which it was. And she sent me for psychiatric evaluation on the grounds I am telling her, seeking my child's interest. My child does not want to go enter the Scarborough police station. And you are telling me, well, you have a mental problem, so I send you for help. And I'm like, is this within the law for a judicial officer to assign someone for psychiatric help or intervention? Sadly to say, I did go to the psychiatric department. The psychiatrist said, what are you here for? He said the judge never said, well, whether your misconduct or your behavior, you're acting erratic or any form. So we went back to court. Keep playing feely bad. I will send you somewhere else. That is a personal approach from a learned judge. So, Ms. Mitchell, you are saying they push us into fear. They intimidate us. And trust me, I was represented. And the attorney said, no, Ms. Clark, you have to comply with the order, comply with the instructions of the court, because that will be the best interest for you and your child.
Hi there.
How am I being sent for psychiatric evaluation?
A little sign in
Sorry.
here. Potato.
How am I being sent for psychiatric evaluation and then have to focus on my child thereafter, after that judge intimidated in that manner?
So you upset the judge, and the judge punished you by sending you for psychiatric evaluation.
Yes, please.
It was well within, the judge had the right to determine that the child could be handed over somewhere else.
Yes, please.
More comfortable and more conducive. But rather than do that, I never say I'm not taking my child there. I'm saying that there is a trauma attached whenever the child has to go there. And you are saying, oh, you have psychiatric issues, you have psychological issues, go for an evaluation. No judicial officer has that right. You did not present as erratic. You did not present as having any sort of issues that would have warranted that. You did not present as a danger to your child. You did not present as incapable of taking care of your daughter. And on the same basis, because you had a right to find the father wherever he was, when he did not turn up to comply with the order, well, you know what? I will take your child and make your child a ward of the state. And listen, because the judiciary is a sovereign state, and because all of its members operate with immunity and impunity, that judge continues to preside over family matters with the same degree of incautiousness.
And it begs the question, what is the purpose of the Law Review Commission or the legal and something services profession? Yeah, that organization. What is their purpose?
Himself? You want himself to review himself?
Exactly.
You need something. You need, but you understand what I'm saying? That is like putting the fox to guard the hen house. It makes absolutely no sense.
But Ms. Mitchell, these are the individuals who are signed by the state and the president, appointed by the president and by the state to deal with our, as Mr. Kevon say, our issues that were brought before them. But they turn the matters into once the verses is there, like the judges are like they're entertained when they see families in conflict or two parties can, like they're mostly entertained with that. To me, the longer the matters before them, they are fully at their best, because I had that matter and this one difficult. And even if there were issues involved, Mr. Kevin, I don't know if you did mention it, sorry, that there are systems in place where there are different officers to intervene and help make the decision making. But I was told, even though the family court, social workers, children authority, CPU makes a recommendation, that learned individual don't have to comply or listen to any one of the recommendations made.
What then is the point?
Exactly.
What then is the point of taking me on this legal merry-go-round if at the end of the day you are going to play God anyhow?
Yes.
And we leave those persons to adjudicate over other matters. Yes. And as Miss Rachel indicated, she heard that gentleman plead, she heard the judge speaking down I've
Yeah.
had a magistrate tell me, don't play loud in my face right here, no, and I'm sad by your worship, what are you saying? Don't play, you feel I'm the next judge, magistrate to get rid of. Don't come in here to me with that, I'm like, this is a magistrate speaking to me in that tone. And I said, sir, I did not disrespect you in our introduction, so you ought not to disrespect me. And I'm saying, so sometimes they have their own, just as they within their clique, they
No,
have
but
their
that's what I
own.
told you. It's a small fraternity. Whether you are
Yes.
attorney, whether you are master, whether you are magistrate or judge, they went to school together. It's a small
Mm-hmm.
fraternity. The legal fraternity is a closed knit fraternity. You would represent me in a matter. And Christmas time, you in the same judge house having cocktails for Christmas. It's the same. We are the only ones without friends in the court. Even when you pay an attorney in full, you are without a friend before the court. The only person with no friends there, that's us, the litigants.
But
So while
why?
the people are standing up for us, they are not.
But while that is happening, our children are suffering because of the due delay, the unnecessary delay. Our children are getting the counseling. Our children are being kept back. Our children cannot go forward. And I'm saying,
Mhm.
is it an approach that we want a particular type of children to remain in that kind of class that there must be no intervention for them and let me throw them aside? Is it that what we are seeing?
Let's take a look at each other here. We can see what we have in common is the maintenance of the status quo. There is an expectation that children who come from parents who look like we do will remain at a particular level in the society. And then who are we to come to pretend we're so educated and knowledgeable of the law to challenge a judicial officer? Who are you
Yes.
and how dare you?
Yes. Mm-hmm. Yep. I'm
Yeah.
telling you, they are never wrong. They never err. I
Mhm.
remember when I was attending matters and such. The court officer made an error in assigning the date. The judge said the date. My attorney looked into his diary. He said, yes, I will be available on that day. I had my little notebook. I wrote down the date. They had they called the matter the Friday before. My attorney and I were in court on the Monday. There was a warrant for my arrest because I did not attend the Friday, which was an error. So when my attorney was like, no, this is the date that we had decided upon, right? No, that is not the date. This is the date that is here. I am not taking that wrong. So her officer could not have been wrong, could not have made an error,
So the
and the
JSO did
error
not.
that and the listen, if that warrant was signed, I was going to be sitting in a jail cell for no reason.
No, you were going to be getting a lump sum from the state for
Yeah,
unlawful arrest.
Tremaine has a hand up.
I agree with Miss Edmond. They are never wrong because
Never.
I had an incident where the judge was belittling me, shouting at me, and being insultive. And when it reached to the point that it was so traumatic that I had anxiety or the attacks, couldn't breathe, and it reached to that point that she traumatized me that much at that point, and I took it upon myself to write to the court protocol officer concerning her behavior and asked for her to be removed and reassigned, somebody else reassigned. Months upon months, they just kept putting off the cases until they sent orders stating that, well, the case is to be heard on such and such date. And I'm like, in front of this lady again, you all are not understanding what I am saying. And then I had to reach out to the secretary of the chief justice, and she said to forward the email to her, which I did. And within a day time, I got a letter from the signed by the chief justice stating that they don't see a cause for the judicial officer to go before the disciplinary committee. And I'm like, but I never asked for this lady to go before the disciplinary committee. I asked for her to be removed and somebody else to be reassigned because of her judgment, because of her behavior, because of her biasness. And I wrote them back and I asked, okay, well, what methodology that did you all use to come up with the idea that she did no wrong in a daytime? In one day time, how could you come up with that assumption? That was just it was an assumption that she did no wrong. And I reached to the point that I had to withdraw my matter because I was tired, I was exhausted, my family was traumatized, and it had no end in sight. And I had to withdraw my matter because of that, not because I wanted to. It's not because I wanted to. It was because of the trauma that judicial officer had inflicted on myself and my family. And she was presiding over another matter that I had before the court. And it was only after the fact that I got a email, and it was a court that stating that she recused herself. After the fact. Why didn't she recuse herself before, when things could have been amended, when things could have been different? After the fact that I withdrew that first matter, you decide, okay, you're going to recuse yourself. They are never wrong. It has been recently that I applied for office copies of the case that I brought before the court, and they are telling me this is confidential information, that they can't give it out. This is a case, a matter that I placed before the court, information that I gave to the court, and you are telling me this is confidential? I can't understand how that can be confidential, and I need to see what's in those reports. If it is that these people took what I was saying, if they twisted it, whatever they did, I need to understand what went wrong in that court. Because something definitely went wrong. When my daughter ran away, nothing was done. Nothing came out of it. They made it off. They passed it off as like if I encouraged the child to run away, when in fact they did nothing, when they were warned beforehand. So I need to be able to see what are in those documents and who was negligent, because clearly that is gross negligence. A child cannot give warning stating that she's going to run away. You all were informed, did absolutely nothing. And I was stuck in a place between a rock and a hard place where I had to make a decision, knowing that this child going to run. She don't know when she's going to run. Or tell this child, you know what? Go to the police station. That she was going to be safe at the police station. At least I know she was going to be alive. She was going to be safe there. When she run and go, God knows where, she could have ended up dead. And that's because you all failed to protect her. You all failed to intervene. And the thing is, you all now are telling me that it's because of me the child run away. Come on, the child made several cries for help. And it's like, according to you all, it's like this big clique. Everybody protecting is about secrecy. It's not about transparency. Everybody want to cover everybody back.
Yes.
The secret must never come out. If I don't have a problem. We are all humans and we make mistakes. We all make mistakes. The problem is not the mistake, the problem is identifying that you make a mistake and making amends. If you want the public to continue to trust you all need to admit, okay, I made a mistake. Not everybody running out money, but people will begin to sue when they realize you all it's all about a cover-up. Everything is a cover-up. You all cannot be honest with the life of God, even through the Freedom of Information Act. You're requesting information, and they're telling you it fall under the this particular
exemption
section that you can either get it redacted or you're not getting it at all. Come on, where's the transparency? We need some form of transparency if we are to trust these agencies and trust the judicial system. A lot of people have no faith in the judicial system because they are clearly seeing they don't have the best interests of the children and family at heart.
Because you're so correct, because I remember I had a single DV pending application before a magistrate. And the other side's attorney came with a high court order, the same breach alleging that I refused to hand over the child. And about 15 attorneys sat down in the little legal part where the attorneys sit. And they all shouted at me, you need to give the man the child. And I'm the victim here hearing, give the man the child, but I am before the court. I am the applicant seeking protection from the said individual on the application for a DV, and you have the so-called magistrate, the so-called legal officers who were not involved, who were not part of the matter, instructing me to hand over the child. And what was sad? The following day was the matter in Trinidad, and here the learned, I can't say learned magistrate, but the magistrate at that point in time, Miss Clark, I am not dealing with this DV application today. You know what? If you know what good for you, when you go down to Trinidad tomorrow, carry down the child. So I said, but your worship, I have no instructions to carry the child to Trinidad tomorrow. You hear what I'm telling you? That's what she's speaking to me. You hear what I'm telling you? Carry down the man child for him tomorrow. How a domestic violence on behalf of Arita Clark has anything to do with a custody or access matter? What is really the function?
Exactly.
What is it? Are they really doing their jobs effectively?
And I want to add this, Arita. I want to add this. In matters where you are saying this is the protocol, right? Let's say the child is being abused and report is made, etc., etc. In my case, my daughter was never given psychiatric assistance, mental health, nothing to help her recover. But you are saying you are interested, you are seeking the best interest of the child. The only time she saw a psychologist was for the psychologist to say, yes, this child is telling the truth. That was the only time she saw a psychologist or psychiatrist or mental health professional. That was the only time. Right? And I was looking at the family court website. They were talking about mediation services, counseling services, and all these different services. And my matter did not go through the family court, but this is what I was saying earlier. A lot of these services and things that you all are saying that is available to us is so disjointed. It's so fractured. It's not coming together. It's not gelling. It's not. There's no synergy, right? And then even if I am saying good, because I know Arita told me about her matter where her child has not received any sort of counseling either, and look how long she has been in the system, right? You are saying that we are concerned. If you see something, say something. Children are our priority and all these different things. We enact this law and that act and this and the other. But what are you all really doing when it comes to actually seeking the best interest of the child?
Miss Edmond, we have so many cases when we set up these bodies, because all they make is excuses. When we set up these bodies, we expected 900 cases for the year, and in the first how many months we had over how many thousand, and we don't have the resources. Do you know how many
trained people?
Do you know how many graduates from COSTAT, UE, USC, sitting down here with social work degrees and waiting for employment?
Exactly. Hire them, train them.
Let me tell you something. Miss Clark and I were speaking recently, and I said to her, and she will bear me witness. I said to her, Miss Clark, do not wait for the court to appoint someone to get mental and emotional and psychological intervention on behalf of your child. Get up and seek it yourself. Because here's what, the Children's Authority put a recommendation for my child to have intervention, trauma counseling, and all sorts of wonderful things. And they referred the child over a year ago. Nobody here called me yet, Miss Edmond. But my daughter is seeing a trained counselor at my expense because I realized that there is a need.
Yeah.
And as a parent, I am making the sacrifice because I understand the trauma that she went through. And I understand how significant that can become later on in life. Because when we put layers on a cracked foundation, sooner or later, these children give up. We see behaviors begin to manifest themselves later on, and we can't trace it, but they are unresolved issues. And I said to her, do not wait for the court to give an order. Do not wait for National Family Services, Children's Authority, or anybody else.
Miss Mitchell,
do it yourself.
Miss Mitchell.
Yes, honey.
You remember I left Tobago to go to one of the #1 child psychologists located in Champlain?
I didn't tell you go there.
No, I'm just saying,
No.
I tried a therapeutic counselor. I tried about 4 or 5 different private and public entities. And all because you have a matter before the court, we cannot intervene.
You're not going based on that. You are going as a parent who wants intervention for your child. It has nothing to do.
Miss Mitchell,
Let me tell you something. You do not have to mention the court.
Miss Mitchell, there were 2 occasions I never mentioned the court. And before I could finish the conversation, hold on, please, Miss Clark, I just want to make a phone call. And by the time they come back, you didn't tell me you have a matter before the court. It's up to the Children Authority to intervene, because once the matter before the court, there are the bodies involved, inclusive of the family court and Children Authority, who have their special experts and assessment team. Yes, Kevin.
You know what is going to happen? Anytime anything happens with your daughter, they are all going to turn around and they're going to singularly blame you.
Understand that? Yes.
Having done what you should have as a mother.
It brings me back to the various institutes and the merging factor between this whole issue. Because by law, there's something called assessment order.
Yes.
And that assessment order will tell you what happened to whoever from before, during, and what to do after. However,
Mr. Kevon, some of them learned individual, none of the law, you know.
Well, I don't know the law. I don't know the law.
And many
times, I don't know the law.
Right, we don't know the law. But
I like to read as a boy.
Of course. But that is under the Children's Act. Because I remember, not cutting, keep your thought. I remember mentioning about the International Child Abduction Act. And the magistrate stood down the matter to go and investigate, ask what Ms. Clark talking about. Yes. And the other side attorney said, Ms. Clark is correct. And all I'm simply saying, a father or mother cannot purchase a ticket. Who is the parent accessing the child when the custodial parent was not involved or informed to take the child to the jurisdiction? That was my clear point. It was, and you are speaking about the assessment order, about 9 of them. And so far, between the 5 of us here, I have not heard any of those orders applied in any of our matters. Go ahead, Mr. Kebon.
Now that is the stress that citizens are facing. Having to have an issue, find the solution, and actually tell the people who's supposed to implement the solution how to do it, when to do it, and why to do it. I think that is the issue with especially family issues. That we have all the solutions to our problems, but we have to go to relevant people as the third party, legal services, to get that sort of guidance and implementation. And we are not getting it. We are not getting it, as well as we are not getting it in a timely manner. Issues that we all have, the 5 of us and maybe others, can be dealt with in a specific time frame as well. And I think the longer something keeps going on, is the more traumatic it is the more stressful, is the more questions you will ask. And I am saying, as a citizen of the Republic of Trinidad and Tobago, who have experienced a lot of things, if I start to talk, I've been the following might just go so woof. Yeah, because it's facts, because I like to write and document. But however, the holistic approach in this matter is that where are the people and the institutes who are constituted? Because they always have these constituted institutes with director and acting director and all these top heavy people with PhDs and very you hear the word that is used? Learned. Where are all these learned persons in these matters that could be concluded in the shortest time? Why are these matters and why are these issues arising? Where there are laws, where there are even self-precedents to set internationally that we could use to solve these issues because I am telling you, you see the right of the child is override. You see the roles of the parents, it's mixed up. You see the roles of the institutes, it's confused. You see the responsibility of persons, you have to tell them what to do. In all the professions, and all from the legal services to the social services and all. We mix up psychology with sociology.
That's
Yeah. We don't know how to separate. Yeah, we diagnose when we're not supposed to diagnose. We talk out of timing when we're supposed to be in timing.
that's right.
So much of things seem to be confused in this right, role, and responsibility. I call it 3
But you
R's.
know,
The 3 R's are really mixed up.
I came back here as a social work student, still having been doing my studies in Barbados. So when I heard about the family court being established in 2004, I say, yes, things will work out and it will be the best interest of the child. Poor me, social workers sit down in the court system from Tobago magistrates, Scarborough magistrates, court to the family, to every system within the judiciary. To sit down and hear, still confused as to how on earth you had an agency established called the Family Court with a mandate to protect our nation's future and all the mashing up our future.
That's right.
I want to just make one point here in relation to what Michelle was saying to Arita in terms of getting mental health counseling and things like that. I think it is grossly unfair, especially to single mothers, to ask them to do that or for them to take that responsibility up. I understand you have to do it, right? Because you want your child to recover. But it is wrong because you are the one traumatizing my child, not me. You. And now I have to pay the price for you traumatizing my child through 5 and 10 years of court battle.
That's right. It's unfair.
Until a precedent is set.
And then apart from that, it is something that is offered by the court for free, and you are not given me the opportunity to access it.
Until a precedent is set where one of us or one of the thousands out there sue the family court judicial system for damaging our picnic, then the lesson will be learned. Then the learned individuals will know their roles and their function, their responsibility. But until then, we will be prejudiced against. We will be the black hen chickens, because who are we as parents to say, what do we know about advocacy? What do we know about the rights of a child? Or let them go to any special, or I often say the PhD is somebody, a person holding a degree. We don't have that PhD. So who are we to come before them? Yes, Ms. Mitchell.
One of us. It has to be a class action lawsuit.
Definitely has to be.
The way up to.
It has affected too many of us.
Action lawsuit, because people lie, but patterns don't.
Yes,
And
exactly.
this is a pattern. So it's not you or Tremaine or Miss Edmond or Kevin, not me, to take up that mantle. Because for every one of us seated here, there must be dozens, scores, hundreds outside who have had the same experience. But you see a class action lawsuit?
yes.
You see, that's how we have a police complaints authority. You need a judicial complaints authority. You need a body established to give oversight.
Because too many decisions made that are affecting even divorce matters.
The decisions are being made in an ad hoc and arbitrary fashion, and then sometimes in an adversarial way, because that judge made herself your adversary. Now, I want to know, what qualifies you to preside over family matters? You can't come from the Environmental Commission, after you come from the Industrial Court, after you come from some magistrates court where you be shipped left, right, and center, to sit and preside over family matters.
No, most of these judges, they do a little mediation course, so they call themselves mediator.
My girl has a master's in mediation. You catch yourself.
That's why I could say that. And I'm saying, you are a specialized mediator and a legal profession and a judge, and you can't help, you know, a matter is acrimonious before you. And if you have a master's in mediation, have that distinct level of education to know how to mediate between parties, and you causing conflict between the two parties?
Why is it the last place you go and not the first? Why is it not the first thing? Miss Edmond, when my daughter, this was a whole allegation. It was a lie. It was investigated. The police said, you lie, you make the child lie. That the other party did that, right? I realized that my daughter was damaged in the time that she was kept away from me. I didn't wait for no children's authority, nobody to tell me my child needed counseling. I got up and I made whatever sacrifices I had to take my daughter for counseling. I told the learned judge the child is in counseling. Is the counselor qualified? That's your only interest, if the counselor qualified. I told you in July of 21 that the child was in counseling. You decided in February of 22 to have the child sit with one of the court-appointed psychologists. The psychologist came back and said everything that I said and more. The psychologist said any access must be at the family court and only after the other party goes to counseling, and only when the child feels comfortable, safe, and secure to participate. You know, when you look at me and tell me, sit down with him and discuss access before the court has to make a final deliberation. And you set a hot trial date.
To me, Ms. Mitchell, to me, everything about the court is that the judicial officers don't want to do their job. So the easiest thing is to collect their $47,000 plus as magistrate, inclusive of all the perks and allowances. Collect the 40,000 plus, sit down, do 10, 15 matters a day, drive off in the BMW, the Mercedes Benz, and then go their way. To hell with you and your children and your problem. And I am saying when these officers retire, is we, the parent, have to fix our children and our problem.
No,
and if we
when they are done with our children, if we as parents don't get up and get intervention for them, the children who were damaged by the family court will end up before the criminal court.
You're correct about that. You are totally correct about that.
So you causing issues at one and feeding the other end, but you're all talking about judicial reform.
But Ms. Mitchell, you know what I have an issue with? My biggest issue is the terms that these judicial officers use. This is my court and I can do what I want. No, it is not your court. It is not your court and you cannot do what you want. You want to be guided by the laws of the land. This is not your court. You are there to represent the people of Trinidad and Tobago. Yes. So I think they need to stop using that term. That term irritates me. You cannot use it, please.
And Tremaine, what I learned years after, when we hear the word court, it's an individual we are speaking about called the judge, master, or magistrate. So when you go back to court and the court make a decision, and not the court, no, because I often ask the question, right? You are a learned individual. We all make mistakes, as we all know. And you have an acrimonious, complex case before you. Can't you seek assistance from a colleague or somebody above you? Can't you say, let me get some advice from another colleague? What is it? What is hard? You feel you're so bent on you're in power, you're in control.
In my courtroom, I am God. In my hearing room, I am God.
There is no humanity in their decision making. They are just, I'm going to look at the precedent. This is what happened in this matter before 20 years ago, and that is it. So we will work this way. That is it. There is no humanity. You do not see the persons before you as a family that needs help. They do not see that.
You know, I'm thinking currently, if one of us or 1,000 of us could set an example that when these judges make decisions and we take it beyond the Court of Appeal and go to the Privy Council, I better they behave themselves. But you know what? They shut us down so much. And I often wonder, is it that you are burning out either parents? So by the time the 6 years and the 7 years reach, you just rush a decision. So when the family say, the amount of money we spent, thousands of dollars we spend behind attorneys and this and up and counseling, and when half of we account emptied. So when we're done with them, they can't go beyond High Court. They can't go beyond Court of Appeal. And I'll always commend the attorney who made the application for me at Court of Appeal. And she said, Ms. Clark, where you going? I say, see me and that judge there. That decision she made, I know it was not within the law. And there it was, Miss Clark, this Rita Clark playing fresh to say she making an application against this learned judge. But I had to do it because I was punished emotionally. I was psychologically, financially abused by one individual who chose not to do the right thing. And as Kevin and Tremaine, and we are all saying, there are laws, there are guidelines, there are rules and regulation. For instance, there is a there's a Property Act where they look at the guidelines, the different rules of all of the court and blah blah. And to me, Miss Mitchell, you and I mentioned that, Miss Rachel, you know that too. That these learned judges that mix up the law so much that if we make a mistake and call the wrong act, it's okay. But these learned individuals, I will always distinctly and I remember that learned judge in my case again, she assigned attorneys from the the Solicitor General's office, call themselves child advocates. Well, I confused as to but how my child was awarded the court minutes, child advocate representing my child. What is the problem? When we go and read now, it's under the the Matrimonial and Proceedings Act, the learned judge assigned advocates for 6 years now. 6 different attorneys assigned in to represent my child. And to date, not one made a proper representation of my child to say, Your Honor, or my Lord, or my lady, Miss Clark's daughter, X, we think this and we think that. They sat there and they said not a word. What is their purpose before the court?
Because the best interest of the child is not their focus. That is the simple answer. It is not their focus. And we can see it plain as day.
Yeah. You have a responsibility to read, These people do not read. They do not keep walk around with the law. They keep bandying about expressions such as international best practice. Yeah. Imagine you are given an order in my matter and you're talking about things like parental alienation.
We talked about that on the last program.
Where did that come from? How does it become part of an order here? How do you send to determine whether parental alienation is relevant or applicable in this matter? Number one, I don't even know if we cite it in our laws. And number two, it is very, very clearly defined and it is not applicable in this situation.
Exactly.
Stop just in terms about when you do things like that, it should negate the order in the first place.
Ms. Mitchell, what about the famous phrase, a parent has a right to access?
A parent has no right to access. A parent has a responsibility to seek, secure, sustain, and safeguard the health, welfare, and well-being of his or her child. The child has the right of access to a parent who is doing that.
And
exactly.
that is in the Family Law and Guardianship Act that you are quoting.
But they don't know this. They don't know this. How could you not know this and be presiding over family matters? You keep misappropriating rights. You're giving parents rights which are not theirs.
Yes,
exactly.
Yes.
And you're hell-bent on going down. And let me tell you something. We talk about all the links in the chain because a chain is as strong as its weakest link. But when all the link them, we can bust. What's going on with me? And you know what? Not one body will look back and correct the errors of the other body. They compound the errors.
Yes.
And who suffers? We suffer emotionally because we are traumatized and we are re-victimized and our children are re-victimized.
But I don't know if any one of you all have experienced this, that you have an attorney and you say, but that is not true. Hush him out. Wait until the master says something.
Yes.
And I'm like, and sometimes your attorney, know to him or herself that the other side is lying. And because, as you rightfully say, Ms. Mitchell, you're afraid and you fear the learned judge will victimize you in other matters. You hush your mouth.
And I'm saying, you're talking too much.
Yes, but when you hush your mouth, you're hushing the child. You're muzzling our children, because if it is you are our voice in the court, in that system, and I'll always go back to the Barbados system of a family court. A magistrate or a judge presides, yes. Within that court setting, there are officials from education, Ministry of Health, a whole multi-sectoral approach. And before the individuals leave, and as Mr. Kevon said, this adversarial approach will be like this fighting approach. No. Before they leave that matter, they sit down and they ask each expert in their own profession. If the child is deviant, you think the child needs counseling, you think the child have academic problem, you think this, you think that. When you leave it all up to one agency called Children Authority or one agency called Family Court, where I often say have square pegs in wrong holes, it wouldn't work. If these so-called, but let me not say so-called, if these social workers and these experts sit within the matter, they could help guide, but not the learned judge, but help guide the learned individual at that point in time to say, Your Honor, or my lady, or my lord, this is what is applicable by a social work. This is what works in cases of situations like that. But when you have the one judicial officer and no, he head from a foot with regard to social work practice policies and guidelines, as Kevin is saying. When you have individuals who have social work degree mixed up with minor and a minor in biology and a law mixed up with a minor in some other field that is no relation with helping and mediating families,
yes,
creating a problem. All we are saying as individuals here in Trinidad and Tobago, get the right fit for the right cause.
That's right.
May I interject?
Important for you to not have the right fit. Go ahead, Kevin.
May I say something? Apparently, this discussion is happening intangible with understanding that the persons within the legal profession understand that there's an issue in judicial skills. Because I could see from in 2020, I think the United Nations funding to the Chief Justice to run different courses for judicial officers and legal professionals in the area of being the voice of the child enhancement judicial skills. So clearly, they have even identified that there is problems within. Clearly, there is problems within, and they have identified. How fast do they fix it? I think that is the problem that we have, and I think there is no forefront to fix it.
No, you
There's
might be
no
telling
way to
yourself
fix
that
it.
they identified a problem, and it's not necessarily so. Internationally, the United Nations may have recognized the problem and may be offering the courses, and so they go and they avail themselves. But when you avail themselves, there is no application. So you went and do a course for the sake of doing a course.
Yes.
It's not that
Michelle,
it's sorted out, is that it was being offered to us because it was being offered worldwide.
Miss Michelle,
Identified a need.
all I often say is just judicial officers getting a free ticket, free hotel accommodation, free meals, and spending money to go to another country, right? And that is their purpose.
Miss Edmond, we just jealous because we didn't do law. Now what happened?
Miss Clark, what I have an issue with is the fact that, as you all rightfully say, in the courtroom we have the master or the judge, then we have these quote unquote child advocates, then we have the attorneys for Children's Authority in the court. When there are certain questions answered, the attorneys cannot answer it because they are not social workers. Why aren't the social workers involved in the litigation process and in the court while the matter is occurring? You cannot have an attorney just with an affidavit from the social worker and they're reading it so and so. No, that is not in the best interest of the child. The social worker is the one who is there interacting with the child, doing the monitoring of the child. So that person, he or she is supposed to be involved in the matter in the court. So the master or the judge could ask this person, what it is going on? Tell me what are your thoughts? Besides the fact that you have this and that in the affidavit. Come on, we need
Exactly.
international best practices. It's just like a failure. I cannot understand this.
We like the term international best practice. We like to say it sounds good. But you make a good point. And
Yes.
realize something. When a report is put before the court, they go to the summary page,
Recommendations.
They
They go
don't
to the
read
summary
everything.
page, Let me see what they recommend here. Let me see what the findings are. They don't read the body of it to get the gist of it. And you can tell that very often they're reading it for the first time when you are before them.
But what about the matter recently with the young man who got his 40-something thousand views, and he had to go and cry out and talk about the magistrate this and the magistrate that. And I'm saying, you, the magistrate, have an application before you. No questions asked. You abruptly made a decision. Didn't think about the adverse effects on the child. Well, the good thing about it, the gentleman got back his son. He has custody, care, and control. And here, I was told that the magistrate asked the individual, or told the individual, shall I say, you're lucky you didn't call my name because I would have deal with you. And
Excuse me?
I'm saying, you're lucky you didn't call my name because you know that was legal ramifications. And I'm saying that individual, at first people would say, well, why he did that and he had a matter before he court, but he knew to himself the magistrate was wrong. And I smiled when I heard the name of the magistrate because I was before that said magistrate where I had to write to the chief magistrate to get that same magistrate removed from a matter before me. And I'm saying I couldn't believe he was still in the system making decisions.
Miss
Doing
Clark,
the same things. According to you, Miss Clark, doing the very same things because they
Yes.
are not held to account because
Accountable.
no consequences are brought to bear when they are incautious and when they mismanage our matters.
and you see, the thing about it is not only the family court, because when we pick up the papers on a daily basis, we see cases being thrown out, people being set
Whatever.
free when they're not supposed to be outside because of errors being made by these judicial officers, and then they're getting promoted on top of it. You know, they're sitting before, on matters and making the same mistakes over and over, and yet there's no ramifications. Why is it? Why
Because
is
look
it?
I remember one of the advocates, child advocates from the Office of the Solicitor General's office. And she today interviewed my daughter for 4 hours. And I said, yes, when they go to court, I will hear a true representation of my child. You know, the people sit down there and not say a word.
A word.
They came to Tobago, they stay in Cape Park, not Cape Park, sorry, Cape Park is in St. Anne's. They stayed at a special hotel, I can't call the name, special hotel here in Tobago for the entire weekend, so they're doing report. What came out of the report?
The
So
vacation,
yes, that's why I also say a ticket for free spending, free this, free that. And for 6 years, these so-called legal officers who are part of the state entity claim to, well, appointed by the learned judge then to represent my child. And the question I often ask myself, when those 3 advocates were appointed, you know what the grounds in which they were appointed? I brought a DV application against the other party. The other party filed an emergency application in the High Court stating I make an error. And the learned judge, instead of she find out what really is the problem, or say Miss Clark and the other party all go back to magistrate's court, she decided to appoint these attorneys. So I said, okay then, the attorneys are coming on board. They will properly represent my child. 6 years after, they failed. 6 years after, my child still don't have a voice.
But
6 years.
the thing is, in the Children's Act, I read that, upon receiving a complaint concerning a minor, they are to notify the police. They are to notify a child advocate immediately. That never happens. That never happens. Why is there? The law is there in black and white, but we are not following and we're not enforcing the laws. Why isn't there when the issue arises, when the child is going to be questioned, why is there not a child advocate, a child attorney assigned to that child at that point in time to
Ms.
go with that child?
Ms. Tremaine, there are 2 sets of child advocates. They are the ones from the Children Authority based on the Act, and they are the ones from the Matrimonial Proceedings Act. The ones from the Matrimonial Proceedings Act, who are the ones appointed in my matter where we have no divorce, are the ones where both parties are going through divorce, and they are the voice of the children. In the Children Authority, their function is to represent a child and properly and legally. And I'm confused for today. Most of these children they say they have over 321 cases before the children court. How many of them are properly represented? When we have our children, I remember Mr. Kevon citing in the past that a restraining order was brought against him from the Children Authority. Where were the legal experts called the legal officers or the child advocates in this case here? To follow up with Mr. Kevon's complaint, even if he went through the Children Associates and whatever positions they have, what is the purpose of a legal department within these state agencies?
They don't know.
And like they sit down in court, you know what bothers me?
It is
My lady,
obvious they don't know because we have to point out to them. We
My
are
lady-
going to them and pointing out to them where they are making errors.
my lady and my lord, could you have the matter adjourned because I haven't had chance to interview the child? Or my lady or my lord, I think we need more time to get some clarity. And what do? They come back again 6 months after. My lady, Miss Clark, was very difficult to deal with. And Miss
God.
Clark refused to
Oh
answer
my
the
God.
question. And it's so that they treated Miss Clark for 6 years.
Yeah, but Miss Clark, clearly you are the problem.
Yes, yes, not it, yes, yeah.
I think they are all agreed collectively that you are the problem.
Yes,
You know
yes.
Miss
why you are the
Mitchell.
problem? Because you want to play your reading and you want to play your
Yes.
understanding law. Let me tell you
Yes.
something. The law is simple and straightforward. You know why it is? Because the common man has to be able to read it and
And
to be able to
understand.
comply with it or to obey it. That is why it's simple and straightforward. But they confuse it to tie us up in the system. And then they want to
Yes.
use that confusion to flog us and to frustrate us until we finally give up.
Yeah. And then they say that the court system is overburdened. We have too many matters in front of us.
Because their judicial officers are incompetent. They
Exactly.
refuse to read. You have a matter coming before you, and I have a problem with fast food justice. You can't be having matters 20 minutes apart in the high court, in the family court. 20 minutes apart, you taking longer sometimes to get an order of pizza at Pizza Hut than you're taking to get justice or access to justice. That cannot be. You can't have so many matters on any one day. 9 you're hearing one, 9:20, 9:40, 10 you're hearing one, 10:20. No, 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 no. And then it is quite obvious to you. You have a responsibility as a judicial officer to know what is coming up on your docket on any given day and to go through the applications, go through the affidavits, and to make notes. If
Sure.
you would read
And
many
Miss McCarroll,
before the court so long,
I often say as well, if it is I applied January and my matter is heard in March, what is wrong with immediately appointing a probation officer? So when the matter comes before the judicial officer,
you
he
have
or
that
she has an
information.
understanding. So let me say we go to court the 3 months after and rain fall and the magistrate couldn't make it from Trinidad to Tobago, a matter adjourned. And then another 3 months come, they had a strike, matter adjourned, that is 6 months. And another three, I have been through that. I'm like, what is going on? All
Yes,
it is simple, and Mr. Kevin, you said it. We want the matters to finish in an expeditious way because our children are hurting. So
yes.
I often say, custody, access, and maintenance before you get a probation officer's report one time. Because
One
if it's
time.
maintenance, the man coming or the woman saying something and something. If it's custody, somebody on the line is you. Get the reports in before the learned judge hears the matter.
Yes.
Mhm.
When you are given an adjournment date, you get everybody on board at the same time. The SSU, all the persons or parties that you know are stakeholders in this matter, get them all involved from the jump. Because you can't wait, Miss Edmond, for an entire year to pass and then say, you know what, I'm going to refer this to the social services unit and a probation officer will call you and they will set up for the child to go to have an evaluation and we'll come back after that, okay?
Yeah.
So when I told you in July of 21 that the child was in counseling, would that not have been the time then to get the SSU on board? When you was putting the matter to October or December, would that not have been the time then? You wait for all that time to pass to come back in February. And you know what is amazing? You are now telling me that this officer that you appointed from the court, the psychologist, is saying that I am to continue the same counseling with the child that I started. And you're reading it from there because they're saying, Miss Mitchell, are you hearing me? A recommendation here is that your daughter X is to continue receiving counseling. You understand that? She's supposed to stay in. And I'm saying to myself, this lady hearing herself? The very
But
counseling I told you that the child needed because of the other party, you have now had someone that the court respects tell you that the child is to continue to receive that counseling. And you're making sure you tell me, and you're making sure that I say, yes, my lady, she's still in counseling, but you have to keep it going. You hear what I'm saying? You understand? I said, yes, my lady, I understand. She remains in counseling. And after all of that, you say to me, you know what, I think you all should go to mediation.
Well, I was now going to make that point because as Arita was saying earlier, when you have a matter, let's say you have a maintenance matter, an application for maintenance or custody or whatever, you have the every officer that is required for this matter, you assign them one time. And mediation is one of the things that you should assign first. You should not hear that matter until the parties have been to mediation. And
But
because the purpose of mediation is to find a solution. That is the purpose of mediation. So if I have a dispute with this person, you are not coming to see the child, you are not taking care of the child, you are not whatever in, then we go to mediation. The mediator will, assess the issues and whatever. They will assign or advise for further services or whatever. And then because in mediation, the purpose of mediation also is for each party's voice to be heard. And
but
that is one of the reasons why we continue to have matters extending before the court for long periods of time, because nobody is being heard.
Miss Raymond, Edmond, sorry, I think the judicial officers like the lacquery and the bacchanal, and they like the pulling and the tugging.
Yes.
So let me see how long they go fight for. Let me see they go fight to the end. Which one will give up? And it's not about giving up, because it's as though you're putting us. We are in the gladiators era. The gladiator will fight to death.
Yes.
I'm saying parents are burnt out financially, time out from work, and you sitting down there and you satisfied. And if you deal with a matter within 3 months, come on. 6 months, 8 years for me right now. And
custody matter between parties that have not been married not supposed to last longer than a year.
100%. And I'm sure most of us were in that situation. Unmarried people having matters before the court. And because you can't, under law, once parties are unmarried, you cannot bring it under the what do you call it, the Matrimonial Proceedings Act. You have to bring it under the Family Law and Guardianship Act. And the Family Law and Guardianship Act, if I get the correct section, says that the matters ought to be dealt once there's paternity established, once there's certain criteria met, done with that. But you have 8 years, 6 years, 9 years going on. A guy tell me almost 11 years. I say 11 years before the court. What do you think, Michelle?
And that is being allowed, and nobody reviewing or auditing these cases. But Ms. Edmond, let me give you a surprise. Custody was already established in my matter, since 2015, Since 2015, I have been the sole custodial parent. And this is not a magistrate court order. This is a family court, which is a high court of justice order. You understand? And I made a mistake. You know the mistake I did? I got married, and that upset the other party. And I am back before the court with my custody being reviewed. So you get upset, and you told me where the CPU has investigated, and they have it was a lie. But do you think that the learned judge read that when it was submitted to the court? No, she didn't see that yet. She didn't read that yet.
But Ms. Michelle, what about
to address as well? Domestic violence, especially in cases of domestic violence, right? The court, I have found, they do not understand the role that they are playing in having persons who have been abused continue to be abused through the court.
Victimization. Victimization.
Children are part of that domestic violence too,
because
children are part of domestic violence.
Yes.
Children are considered domestic violence. So
under the United Nations, it's called parental.
To fit them in as well too. Children are part of that domestic violence.
They are.
Part of
no, we're not saying, we're not discounting or discrediting them, we're not disregarding them at all.
Because what happened in that, what happened is it has so much of issues. So much of issues resulting out of the family court. There are a lot of people there for over a period of time questioning the ability, the capability, the resources, the educational factors. If it's rejects that are just put there, what is the basis of Why we having all these issues when an
Yes.
institute was developed particularly to treat with a particular type of matter, and we having it dragging on so long? Is that an area where we have a mix up of a number of things? It's an institute to deal with a particular type of matter that have issues that that kind of confusing to me.
But let me give
That family court supposed to be the pinnacle and
yes.
supposed to be the structured area to say, hey, we're getting it right here because we specifically dealing with these issues. And as a result of that, look how fast we're dealing with these cases. We have results of what is their claim to fame? What have been their pinnacle to say I have accomplished from 2004 to 2022 that we have dealt with 10,000 matters. We have dealt with X amount of matters over a period of time. We was able to resolve X amount of matters. I think that is the question that needs to be asked because we'll continue to have a lot of more of us in the silent mode. We
But
just
Miss
in the voice not mode, but it are thousands in the silent mode.
but Mr. Kevon, if you don't know, let me give a little short synopsis of my issue, my cases. So Arita Clark got custody, care, and control of the minor child in 2013. She got maintenance and the other party got access. If one has to take a matter before the High Court, he or she could do it while the matter is pending, or he could go it via appeal. The individual did not do neither of such. They went to the High Court and made an application for custody. And the same learned judge, without investigating, inquiring, treated the matter as though it's a new matter before her. Right? The matter is before her. 5 years passed. I went and applied for an increase in maintenance. I had to do it via the family court. The individual telling the family court, do not entertain my increase in maintenance because the High Court is dealing with maintenance. Confused me, still confused. I then, 6 years after, and before, made two separate, domestic violence application. As of April 2022, the master of the court told me, the applicant, and on behalf of my child, I am not entertaining your application for one, a domestic violence for yourself and the child because you have a matter of custody in High Court. I am not entertaining the increase of application until your custody application finish in High Court. So right now, the family High Court adjourned my matter without a trial date, without a hearing date. So the question remains, what is the position of the child's well-being, inclusive of an increase in maintenance and the protection of the minor? Where are we for today?
In terms of protection of minors, I don't think we take it seriously at all, especially the family court, because I made an attempt to safeguard my children, and I made an attempt to get a protection order on behalf of my children. And based on the allegations, not even an interim order was put in place. So these children were there to protect. They basically had to fend for themselves, and whatever happens. And at the end of the day, even the accused, when the accused was warned about certain instances with the kids, the master of the court went on to tell the accused to get the fit person to bring one of the child for him to see. And this is one of the child that I'm trying to get the court to protect you from. But you have the master of the court telling the fit person, telling the fit person to carry the child for the accused to see, to have access. Tell me how that makes sense. So basically, you placing my child back in a situation to get re-traumatized and to get abused again. How is that even possible? Why wasn't the interim order granted? Why? This has been since January. We're in July. Not one interim order was granted. Several dates of hearing before the court, and no one saw it fit to grant an interim order. Even when I went to the probation officer, he's like, okay, the interim order is still intact. And I'm like, what interim order? None was granted. There was never an interim order. We are not taking child protection seriously.
You know what? When we raise our voices, we are erratic, we are emotional, and we are all sorts of things. What we are not are concerned parents who are invested in our child's welfare or child's well-being. No, we erratic, we irrational, we emotional.
Yeah.
We are labeled all manner of negative things. If it is that the parents listen, as a parent, it is your primary responsibility, as I said before, to seek, secure, safeguard, and sustain your child's health, welfare, and well being. If one parent is doing so and another is not, that is what the court, the family court, was established for, to assist the parent who is. I don't want you to be my buddy or to be my friend, but there has to be an institution standing in the place of the errant individual and assisting the invested and interested individual in seeking that child's interest. But
Yes.
what do? You don't understand your role, you don't understand your responsibility, and oftentimes you step out. They don't know how to navigate their lanes. They step outside
Mm-hmm.
and they muddle and they mess up the whole thing. And you want to now assume and adopt an adversarial stance against the parent who is actually operating in the best interest of the child. Why?
Yes. Yes.
How is this, and how is it that nobody sees this?
But
You
Michelle,
cannot tell me nobody is seeing this.
what I have an issue with is the fact that with the same protection order that I presently have before the court, the CPU has to be recused and the master recused the CPU. How do you recuse the CPU when they are involved in the matter? When there's an ongoing criminal investigation concerning the said matter, and I'm trying to protect the insured. CPU is involved in this criminal investigation, but they're asking to be recused. How this is possible? How could you recuse these police officers from a matter like this, a DV matter involving children that you all are investigating claims against? Come on.
Exactly.
Come on. That is
This
madness.
is like a ball of yarn that you left for a cat to play with.
Yes.
And now we can't find the end from the beginning, and we have to now be picking our way back through it.
Mm-hmm.
And listen to me, this thing is linear, because all of the agencies supposed to be going in the same direction.
Yes.
And as we've been making the point, they need to all start at the same time. If you know the SSU going to be involved, get them involved sooner rather than later. If you know that mediation is a possibility, then that is the starting point and not the end point. But you wait to do things later rather than to do them sooner, and you cause things to become convoluted. And you cause things to become far more complicated than necessary.
Exactly. But it goes back to
operating with this uncertainty because there's this matter. I don't know if I'm going to see mommy again. Miss Edmond, I can't begin to imagine how your daughter felt for those 3 years. A day they pick up your child from school, half day, and that was the end of that for 3 whole years. Nobody considered what it did, not just to her, but to you.
Yes, but this is the other thing. I made I put it in the chat there. We do not even have follow-up services. So that, okay, we've done all of this in this particular matter. What's happening with the child now? Where is the child? Where is the family now?
5 years, yes.
Right? We don't have those services.
Yeah.
But we are acting in the best interest of the child.
Yeah. 5 years from now, they're either promoted or retired. So they're no longer the child.
We need to go back to from the first matter. Let's say up to 2020. Give 21 and 2022, we're still in 22. From the establishment of the family court, from the first matter to now, on average, how long do matters take? What are the recurrent issues in these matters? Where are these children now? How have these children been affected by having been in the system?
And
were they follow-up services offered? Were they needed? Was intervention given? And what was the result either way?
Do you know Barbados have a recall policy that within a period, the same state agencies have to bring back a report to the court to know what, because sometimes 15, 16, these children tend to, we all say, go back into the criminal court system. So to alleviate that problem, the Bayesian system have a follow-up policy that they check back on the child within 5 years whether he or she improved, any further intervention needed. In Trinidad and Tobago, children running away from home and you find them dead after, and that's the outcome of our situation here in Trinidad and Tobago.
Exactly.
And you just get fired and move on to something
Yes,
else.
yes.
Exactly. We
But
are
as we
just we are just too reactionary as a society in terms of our policy making and in terms of
Yes.
addressing issues. We only react when things happen and there may be some public outcry. That's the only time we respond.
Yes.
When we have people who, and then the other thing, they never really because of the fact that let's use just the five of us, we don't have, as I said earlier, we don't have the expertise, we don't have the degrees, but we are the ones who are in it. We are the ones who are seeing what is happening, and we have the wherewithal to say, this needs to change. We could do better in this area. They never consult people like us. They consult people who don't have, some don't even have children.
That's right.
so as we close off this afternoon, I would like, Ms. Edmond, I would like each one of us in our own expert experience tell the judiciary tonight what they need to do to protect our children.
I think there needs to be a revisiting of everything, the entire structure, the ancillary agencies, the sister and brother agencies that are in existence, how they work together or not together, or however it is. We have to revisit all of those things. We have to go back to the beginning, because obviously the system is not working as it's supposed to work or as was desired or designed, right? We have to go back to the beginning. We have to be able to see where the problems are, and we have to critically assess the issues, right? And once we are able to do that, then we would be able to implement the fixes, the proper fixes. We also need to talk to the correct people, right? Because when you're having town hall meetings and all those different things, we are not invited.
Consultations,
We are not invited. I mean, you would have town halls where people would come and all those different things, but I'm talking about where, in terms of policy creation, changes to the laws and all those different things that are required, we are not invited to those things.
Yeah.
And we have to, as a country, looking at where we are, we have to know these things, right? We don't have proper data collection. We don't have those things. We need these things, and we need to listen. They need to listen to our voices as the persons who have been through it, who continue to heal from the traumas that they have inflicted on us and our children. They have to listen to us.
Kevin?
Are you hearing me properly?
Yes,
Yeah.
please.
Okay, great, understand it. From my personal experience that I'm still in, I think it have a lot more work to be done. A lot more work to be done for the guardians of law and the guardians of society. The legal professions need to specify and produce attorneys that could assist our society with children. Right now, we're trying an era with these attorneys. These attorneys need to be trained properly, to be better be guardians for our children. Put aside your ego, your briefs, your money, and stand up for our nation's children. In terms of the judiciary arm of the state, where everything else fails, that institute cannot be failing. And if we are hearing complaints about the last guard for the pot of gold sleeping on the job, then something has to be wrong. And that is my major concern. The serious guards, which is the judicial system, from the judicial officers to the people they employed, to award them reports and stuff like these to guide them. It is a serious thing, and it will get worse. I'm saying to the judiciary, I'm saying to the legislators, I'm saying to the parents, I am saying to everybody involved in our nation, children's lives, that we have to play a more serious part, especially judiciary, which has been failing constantly presently with our children. They need more work. They need more people who will understand parenting, who understand children, who understand to take the whole concept. As parents come to the court and they realize, hey, it's I versus you, take that doubt out of mind. This is not this kind of place here. This is a place that we find solution to problems for our nation children in the best interest. And that precedent needs to set. It needs to set. Otherwise, we will be going downhill and we will just be hearing more and more people with the same problems and there won't be any change. Thank you.
You're welcome. Miss Jules?
Basically, what I would like to say is that these judicial officers, I believe they should have some sort of training in social work, psychology, especially emotional intelligence, because I think we're lacking where that is concerned. We need to have that specialized training in emotional intelligence. I know that the Ministry of Community Development offer these short courses, and I think they should offer their services to the Judiciary of Trinidad and Tobago. I think judicial officers need to read. They need to read the submissions and not just the summary, because when you read just the summary, you miss the errors, you miss the whole gist of the case, and you're just making your determinations based on a few lines at the end. Um, you know, the children's court and the family court, it was supposed to, nurture family togetherness, and it's basically destroying the family structure instead of, building the family. When you build the family, you have a healthier society, you have healthy children and not emotionally scarred and traumatized children, and we need to focus on rebuilding the family and not tearing them apart, and we need to focus, and we need to believe, and we need to know that emotional trauma is real, and they are traumatizing us, further traumatizing us by the decisions that they are making. So I think they need to understand that the family is important, the family structure is important, that we must try at all costs to help strengthen the family system. I know there are cases where it's not possible. There really are cases that is not possible, and I could understand that. But the cases where there is life in the family still, and we could make the family stronger, attempt to do so instead of tear the family apart, and make a healthier society and healthier children by extension. I think also we should in terms of evidence, we should go by objective evidence and not by hearsay. Somebody just can't say, well, I see she do this, or I see he do that, and bam, you have a case there, and you're not providing any physical evidence, not any objective evidence, but the case going on and on. That does not make sense. Basically, I always say, instead of the children's authority, we should have the family and the children's authority. It should be one unit, because in order to have children, we have to have a family structure. It should be hand in hand. It shouldn't be separate. These agencies should not be separate. It should be one entity dealing with everything under one roof. You shouldn't have to go across to the next building or go down San Fernando to get counseling. Everything under one roof. That is what we need. Everything under one roof. And that is my suggestion.
I think they put it together so nicely.
Yes,
From
please.
a synergistic approach, where we need to stop having this disjointed and this non-collaborative approach to how
Yes.
matters are handled. All the key agencies must be on board from the get-go. And
Yes.
whereas judicial officers may not necessarily need to have a course in social work, we need to restructure our hearings and have the social workers and all the other key stakeholders involved and sitting in the matters
Yes.
from the get-go. You know what might be a very good thing? Just how the Hugh Wooding Law School has a law clinic, and their attorneys in training give free legal advice and counsel. Just so you should have attorneys at the family court to help litigants in knowing how to prepare their affidavits, in knowing how to go to court and represent themselves, And judicial officers must not dehumanize and criminalize litigants, because sometimes you are the best person to tell your story. All you might need is a little legal assistance and guidance.
But they wouldn't do that because they wouldn't be
Understand?
making any money from that.
They will be making money because the state will be paying just as the state pays the legal aid officers.
Mhm.
Just
And
how Ramesh put it in place, that you don't need an attorney to be able to file for a divorce and to put your own papers in place. Just how they have officers at the court to guide you in that way, just so they can have attorneys there working at the family court to give you that guidance. Because at the end of the day, whether they hear one matter or they hear 10 in a day, their 40 something $1,000 is sure. Their luxury vehicle without tax is sure. Their ability to travel any part of the world with their families at the state expense is sure. But what we know, this cannot continue in the way that it has been going. This system is not just flawed, it is failed. And we are dealing with the fallout of a culture of failure. And nobody is going back to address it. Only we, the ones who continue to deal with the fallout and who have to look at our children living with the consequences, know about it. But at the end of the day, they go to their homes in their high upscale areas and they live with impunity and immunity. And sometimes the damage to our families is irreparable.
Yes.
What we know for sure is what we are doing is not working. You don't need to go beyond 2022, having started in 2004, to tell you that what you're doing is not working. They need to sit and they need to speak to the key stakeholders, not the ones with the PhDs, not the one with the master's degrees, not the one with the classroom learning, not the ones who can cite the theories for them. The Arita Clark, who has been in the system for 8+ years. The Michelle Mitchell, who is back in the system. The Kevon, who can't get out of the system. The Miss Edmund, who has been victimized and re-traumatized by the system. The Miss Jules. We are the persons that they need to sit and to speak with, because we are the key stakeholders. The system was set in place to assist us, but it is not. So you need to speak with us and to find out where it is failing and how we, who have to deal with the fallout, believe you can put things in place to address and to amend.
so, Ms. Mitchell, Kevon, Ms. Rachel, and Tremaine, the family court has extended an invitation to this NGO to have dialogue with us. And I think this team of 5 will be the team going to have the dialogue with the family court, because we have a petition out called Change in the Family Court Procedures in Trinidad and Tobago. So when they saw our petition, they did come to us. So what we did, we had to highlight our concerns publicly first, because we don't want when we go to them, they shut us down, right? So we 5 collectively will be going to the family court before the end of the holidays. We make an appointment, whether if it's virtual, and we will have a dialogue with the family court as soon as possible. Trinidad and Tobago, thank you very much. It has been a pleasure having you listen to our concerns. We know many of you have similar concerns, and moving forward, look forward to probably on a Saturday, on a Sunday, we have further discussions with issues affecting us, whether domestic violence or issues surrounding children and family, we will be discussing. Thank you very much, Trinidad and Tobago.